sign in to my Hangout as well. I'm doing both the Hangout and this one at the same time, so we'll see how it's going to go. I don't know why it's not working. In any event, okay, turn camera off. Okay, I'm sorry, I'm a little distracted. Hopefully it'll work out. I don't know. I haven't tried to do both at the same time, so I don't know what the problem is, because I'm trying to join my own Hangout. Anyway, I'm just gonna let it go, and we'll go from there. So he really led into the Redditor people, and one thing that is so difficult about people spreading rumors is, and I forget what you call it, but there's a tendency for people to equalize information, meaning, for instance, in civil litigation, unless you can, in my experience and what I've seen, unless you can really show that the other side has a terrible, 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 evil expert, the jury's going to tend to give about as equal weight to your expert as theirs, even if yours is much better. And so that's kind of the problem here. It's like, well, there's this one person arguing this one thing, and Undisclosed is arguing this, and people don't think, well, wait a minute. Undisclosed has legitimate people with lives and careers and everything on the line, and there's some random person with a made-up name that could be 10 other people. Hi! All right, I'm on the Hangout too. So I'm going to try to get back a little so I can look at all of you, but it's probably going to be weird. I'm not trying to avoid eye contact. Oh, now I'm joining the video call. So hopefully you people are there. I'm not trying to avoid eye contact. I'm just there we go. Okay, I don't quite understand how this works. So hopefully people can see me and they'll email me or something if there's a problem. Okay, I don't know what's going on there, so I'm just going to hope that things on the Hangout are working. I know Rabia said she was going to be on there, which is very nice, but I don't know. So let's talk about Debbie. I want to talk all about the Debbie interview and what that tells us about this case, and a little bit about psychology and kind of about how this case went down. You know, I'm not one of those people that wants to take the... I'm sorry, I'm really confused with this Hangout thing. I thought I understood how it works, and I don't know if anyone can even see me, and so I'm sorry to be so distracted. So I hope it's working out there, because I hear some noise in the background, so I don't know if people are supposed to talk or what happens. All right. Anyway, I'm just going to assume it's working, and if it doesn't, we'll go from there. All right. Okay, a bunch of people are joining this call. I think maybe you're supposed to mute unless you... Okay, I can see and hear you, Brendan. I guess probably you should mute if you want to say something. Okay, it's working fine. All right. So I'm just going to talk because I don't understand the Hangout thing and go. All right. So, the Debbie call. Debbie interview. The one thing that has struck me the most this whole time that I've been interested in Serial is the one snippet from Debbie's interview with, I don't even want to call it interview, it's an interrogation by a cop in a school, you know, that already, right, I mean, I'm not trying to get political or anything, but schools are an environment that's a controlled environment, you know, there's bells, you do things, you line up, you know, so you're already kind of in that mindset, and as I understand, the cops did the interview there, so I'm just going to call it essentially an interrogation. We can just look at it that. It's the snippet about the 7-hour conversation with Dawn. Because I think I first saw it, yes, I knew for sure, I first saw it in Susan Simpson's blog post on viewfromll2.com, and the date of it is March 19th, 2005. It's about Dawn's alibi. It's worth a read again. And I'm just going to read you the snippet again, and everything that we talk about is going to riff off of that. And Bob did a great job. I'm not going over all the stuff he showed about the leading that the investigators were doing. It was useful for him to get into detail, but that's so clear to me. And hopefully when I talk about the Debbie interview and what flows from it, it'll apply to all the others. So here we go. McGill, I can't say the name. The guy with a Scottish-Irish last name, the investigator. Okay, however, there came a time when you actually did talk to him, and that was on the telephone. Yes. And how long of a conversation was that? 7 hours. 7-hour conversation? Uh-huh, uh-huh, uh-huh. And at that point, did you realize that Hay was not with Donnie? Yes, I did. And that's what the primarily discussion was about? Right. In the beginning, that's what we talked about, and then, I don't know, I guess after that I felt I knew him. He was so concerned. He was really upset. He mentioned that he figured that Adnan had something to do with her disappearance, but at that point I just thought he had nothing to do with it. So, we're gonna do a little bit of a make-believe thing right here. Because there's thinking, oh, someone should have investigated that, versus realizing the state of mind that someone would have to be in that interview or interrogation of the cop not to investigate. So I'm going to come up with a little story and set this up, just so we can all experience it right now and look into what that tells us about the investigators and about the investigation. So here's our story. We have a film noir movie, the 1940s, so black and white, there's a lot of smoking going on, and there's a, let's just say private investigator. We'll just go from that, because it's always those in those cases. And some distinguished woman, younger woman, walks in and says, I got a problem. Dirk Musgrave. I've got a problem, Mr. Musgrave. I've got some outstanding debt that's owed to me. It's in a bank deposit box. I need you to get at it. He says, sure, I'll take your case. And then, the headline the next day, he sees that this person ended up dead. So he's now invested in it, doing an investigation. And he's going through and he's talking to people, and he talks to this person's best friend. And he sits down and he's talking to her best friend, and he's going through, what could have happened to her. And he gets to the question, and he goes this, so there came a time when you actually did talk to her current boyfriend on the telephone. Yes. And how long a conversation was that? 7 hours. 7-hour conversation? I mean, this should have spawned a whole lot of questions. We have a 7-hour conversation between two people who really don't know each other, and nothing comes of it. This goes away. This doesn't go anywhere at all. And this would be the time that anyone who cared about what happened, let's not even say cared about, let's just say you were a person, you had heard this, and you just had the basic modicum of curiosity. You would want to know about all this. And I guess it turned out somewhere else that she went on a kind of date with a guy. I shouldn't say date, but they went to a movie with her and some friends. I mean, this is a hugely interesting story. I mean, how does this happen? But this detective had no interest in it whatsoever, at all. And so hopefully I didn't really do a really good job laying out the story. This is sort of a spur of the moment thing. But just think about what frame of mind the detective has to be in for that to be the case. I'm just going to give a little personal anecdote, maybe to help. Again, coming from a perspective of a lawyer, having, I think, that same mindset. Unfortunately, when I was a young lawyer, I had a case where we represented the Alameda County Sheriff's Office. It was a combination termination case and actually criminal investigation. There was an allegation that a psychologist there was double dipping, was doing personal work on government time, and there was a lot that went into it. And so I think it might have been my first deposition ever. I deposed the union rep of two of the marriage and family therapist interns that were under the tutelage of the psychologist, and said that she was, bad and a tyrant and everything like that. And I just think there how uncurious I was. I was just kind of had my little point that I was making, psychologist bad, and there was all this other stuff there that I just didn't really, I'm like, I don't even want to get into. And what the other stuff was, is there was some real problems between the, what would you call it, law enforcement staff there and the psychologists, non-law enforcement staff. And the union really had a problem with how the office was set up. And so when this was a third-party witness, so when I finished my part of the deposition, the seasoned attorney, a really seasoned attorney, not the type of seasoned attorney that the state means when they talk about Gutierrez, like a great attorney, he went in and it's not as though it destroyed the case, but he just led her all through about how terrible the Alameda County Sheriff's Office was and that they couldn't manage anything, and that really played into the theory of the case, or his theme, that, the psychologist, whatever they say about what she did, basically there was no supervision. She got into a tiff with the marriage and family therapist, and this whole thing got out of control, and they violated her constitutional rights. So my lack of curiosity really hurt my case. Well, can we just leave it to the system, to resolve this? You would think, well, gosh, someone else will figure this out. And I'm going to make an analogy right now to e-discovery. Here's really the problem. The scary part about how things went down in Adnan Syed's case, specifically in this interview with Debbie, in this one little snippet, and the snippet I'm talking about, if you join later, is when she talks about having a 7-hour conversation with Dawn, that she had reached out to Dawn, they had talked, and they had this 7-hour conversation on the phone, one conversation, and at that point she realized Dawn couldn't have anything to do with it, and it was then that Dawn, at least part of these seeds that were planted, apparently, about Adnan being involved. And in other places, at least it appears to be the case that some of these statements about Hay going off to California may have come from Dawn. So, why is it so, back up. Why can't we just leave this to the adversarial system to resolve? Well, here's why. When I had that lack of curiosity in the case, and really didn't do a good job getting the information, and at least directing it in a way that would fit with my theme of the case and my theory of the case, there was the other side, the counsel for the other side, who was able to do that. And I learned my lesson, and the next time I had a lot more curiosity, and I do today. In this case, the scene is totally different. I think it's really helpful for all of us in criminal cases. I'm not a criminal lawyer, but this is something that I do for myself, and I even think about this in civil cases, is I'm very interested in e-discovery, and I do a lot of stuff with e-discovery, and that just involves discovery of electronic documents in litigation, and it overlaps with a lot of other stuff like IT and also information governance, because in most civil cases, about 80% of the cost is in discovery, so it's very expensive. In any event, so there's something called the EDRM, and I know there's a way for me to share a picture, but I don't know how, so I can't show it. But I'm just going to explain it to you. Let's do it like a podcast. There's this thing called an EDRM, and I think it's the Electronic Data Reference Manual. And it goes from left to right. So the right is a litigation model. So the right is like, the farthermost right would be exhibits at trial. So we're talking about data, exhibits at trial that were initially electronic data, which in the age we live in, 90% of any documents at issue in litigation start out electronically, even if they end up in a paper form. And at the farthermost left of the EDRM is data management, collection, and preservation. So collection and preservation would be, hey, we think these people were involved in the case. Let's put what's called a litigation hold on their email accounts. So let's make sure this evidence, or what we think is potentially relevant evidence, doesn't go away, because we have an obligation we both need it for ourselves and also to produce it to the other side. Okay, so where you are on this EDRM makes a big difference, affects what you should do. So to give an example, typically, even today, if you're going to have exhibits at trial, you're going to have them in a hard copy form, even if they start out somewhere electronically. It would be crazy, so people have done things like this, if you, in the collection preservation stage, at the very far left of the EDRM, printed out every document you would have. You'd have millions of documents, and 99% of them, more than that, wouldn't even end up anywhere at trial, so you even went to trial. So that's the best analogy I can have for this. This is the collection and preservation stage of a criminal case. You're just trying to find out who the people are involved in what happened. That's the role of law enforcement. They're not officers of the court. They are not lawyers. And when they're doing these interrogations, it shouldn't be run the same way as a deposition. That's why, I always have had such a aversion in this case to all these leading questions. That's perfectly appropriate during the deposition. I should say, I've been asking this every time, and the people on Google Hangout and also you people who are watching live through the web on Periscope can't, but can anyone, and I know this sounds like self-promotion, but I'm really interested in doing it, not just for the hearts. Could you heart if you're a lawyer? Could you heart if you're not a lawyer? Okay, well, to push the heart. Anyway, okay. So I'm guessing most people here are not lawyers. So I just want to say one thing about a deposition. Okay, so a lot of non-lawyers. One thing about a deposition. Not a lawyer. Okay, not a lawyer. Okay. So most of the people on Hangouts aren't lawyers either. So what a deposition is at trial, right? You're questioning a witness at trial, and there's two types of questioning. There's direct examination, which would be me. Oh, hi, Rishi. A friend of mine from college and fraternity is on. Anyway, the direct examination would be I would be examining one of my witnesses or a third-party witness. And a third-party witness just means someone who isn't directly connected to either side in the case. Not a plaintiff, not a defendant, not named by one of the parties as a witness. And when I'm doing that, I have to ask non-leading questions. And so that would be questions that don't suggest their own answer. So it doesn't cover the gamut, but just think when, where, how, why questions. Those are the sorts of questions that are direct examination questions. Those are the questions that journalists should ask. And a direct question would be, so you walked down the hall. You went to the door. A lot of times they add these parts at the end, like correct, right, which you shouldn't do. But I won't get into that. It's much better just to have a statement and make the witness say yes or no to that. But that's what they're doing. That's what they're doing here primarily with Debbie. And the thing is that, okay, in a deposition, it's similar to court, except you're in a conference room somewhere. There's no judge. There's the witness. There's opposing counsel. There's a witness's counsel called the defending counsel. And things are recorded. And objections, because there isn't a judge to rule on them, they become really a difficult issue. And kind of obstructionist tactics by either side become a real problem because there's no adult in the room. There's no judge who's, as it would be a trial if you listen to some of the trial testimony in this case or other cases, the judge is ruling on objections, and so it really puts a limit on the funny business. But depositions aren't that way. They can get really nasty, really difficult on both sides. For the witness being deposed, it can be very hard because I'm gonna give you a funny definition for depositions from a book called The Curmudgeon's Guide to Practicing Law. And just know I'm actually going somewhere with this connected with Debbie, but I just need you to go down this journey with me. And so there's a part of this book called The Curmudgeon's Guide to Practicing Law that's by Mark Herman that's very good. It's funny and interesting. And under definitions, he has a definition section, I'm sorry. Oh, yes. And his definition of deposition is deposition taking. So this is how the person taking the deposition experiences it. 7 hours of pretending to be a sociopath while locked in a room with an amnesiac and a compulsive obstructionist. So, right, you feel like a lot of people when they're taking a deposition, they have to be really hard-nosed to get the answer, and the witness is pretending to forget all sorts of things. Think of the I don't recall answer, and the opposing counsel is trying to obstruct. And then the definition for deposition deposition defending is 7 hours locked in a room with a compulsive talker and a sociopath. So when you're the person defending the deposition, you're trying to keep your client from giving away the store for no good reason, going along with all the tactics that the other side's doing. It's very hard on both sides, any way you slice it. And I'm going to play a quick little bit from the Justin Bieber deposition. I just want to give you an example of how bad things can get in a deposition in terms of obstruction, if it comes up. Yes, okay. So it's going to be, I'm going to get it as loud as it can. And if you can't hear it, just tell me and I'll just give it up and consider this a failed attempt. All right.
Remember earlier today when I asked you, why don't you listen to what I have to say first? And then maybe you'll tell me this.
I don't have to listen to anything you have to say.
My question.
Today,
you have a question about my question?
Today,
you have the right to be clear for you to be able to be clear. Being in Australia ever?
I don't know if I've been to Australia. You been to Australia?
Are you aware that Scooter Braun knows that your bodyguards have attacked photographers?
Objection to form. What kind of question is that? That doesn't make sense.
That's correct.
That doesn't make sense. That's a weird.
So if you heard any of that, if you don't, I apologize, but if you heard any of that, you can see that it just gets ugly and it's very hard to know what to do. But the difference is that when you're the person defending the deposition, you can prepare your witness for it. So you can do mock depositions with him and deposition training and show him or her what it's going to be like. You'll also have an opportunity, although a lot of people don't use this, and I don't understand why. I didn't know about it, really using it until relatively recently when I started with the firm I'm at, what's called redirect, where you can go back and ask kind of clean-up questions of your own client that have to be asked in a non-leading form, but they can solve a lot of problems when the other side tries to put you in a corner that isn't appropriate or right. You can clean it up at the end. And as the person taking the deposition, you have an opportunity to prepare and put documents in front of the person, everything like that. So here, though, right, we have this kid who doesn't know the first thing about the case, and that's Debbie, who's in essentially a locked room at her own school and being questioned by the police. And so, that's the setup. That's what's going on here. And it's really amazing when you think of it that she said as much as she did, given those circumstances. So there was no investigation into the 7-hour conversation. So let's just walk through what we'd asked. When we ask, okay, let's do the when, where, how, what, why. When did this happen? Who made the call? Why? And then for each thing you would have the when, where, how, why question in docs. You would ask about documents that might be, emails, or did you take notes? And you would go through each step. So the conversation, when it happened, whether there were others, how it went, what Don said and when he said it, how that affected what you thought. And you go right down the line from there. To think for a minute about, again, and I don't know about Don. I just talk about him because he's the big flag that we see, and he gives me the ickiest feeling in my stomach. Now, that doesn't mean he's done anything, but I really think he gave other people an icky feeling too, that independent consultant, and that's a whole nother thing. I don't think we still know the full story of that independent consultant who did the weird memo about Adnan giving Hay a scarf, and that was why he killed him. She said, basically, he doesn't seem that into her. What is going on here? And we know that the whole idea, it seems like the whole idea about her going to California came from him. So the next thing I want to talk about, so what I'm saying is, so we see these circumstances where the police, by the way they were doing everything, were excluding all sorts of evidence, knowledge, whatever, that would have come forward if it had been an open-ended process. So they were on campus associating themselves with the school for about a month, telling anyone and everyone that they had everything on the guy. And the problem is that most people's reaction to someone who's very confident and tells you that they're right and insists that they're right is to think, well, I guess they're right, especially if they're young and impressionable. And our reaction probably should be, they're probably wrong. And I have what's called, and I don't mean to criticize him, I'm sure he's a wonderful person and maybe a good actor, I call it the Stephen Baldwin rule. And because there's a really good commentary in the movie The Usual Suspects, and there's a lot of people in there. Kevin Spacey's in there. A lot of other people have gone on to do other things. And except for Stephen Baldwin, he hasn't done much acting that I know of since then. And he was the only one that in the documentary seemed almost belligerent about what a principled actor he was. So there's this scene in there where he's being really Baldwin-esque intense, saying, and I told that director when he offered the part, I'm a serious actor, this has got to be serious, we don't screw around. And, and the guy went on for a few minutes like that. And my reaction to that was, well, we know who isn't a serious actor. The person that's telling you how serious of an actor they are. Kevin Spacey, if you interview him, is not going to tell you, I'm the most serious actor in the world. He's just going to show it. And so that's the thing that you see with the police. They're there at the school telling everybody that they've got everything on the guy, but they're not going to tell you what they have. And it looks like for a second, I'm breaking out in Hangouts, not moving. Anyway, and so you just have to think, okay, so there's all this information that we have no idea about because the very act of the investigators inserting themselves into the school, being there for a month, and telling people they have the right guy, change people's memories, change people's ability to share what was going on. And then you have that they were doing these interviews there under the settings and the way they did the interviews, just the fact of doing them, especially a month after, later, right? Because I think Bob's right to point out that they waited a month. And that obviously affected things. I shouldn't say obviously, that affected things. Because that's another thing I say. If someone adds an ly word, like obviously or clearly, it's probably not obvious and not clear. So if it really was, they wouldn't have to say that, so try not to. And then the way they conducted these interrogations got rid of a lot of evidence. And in some cases, they'd come back twice and keep whittling it down. And the problem there is that when we get to trial, there's not as much for the defense to work with because they already have these witnesses that have been so influenced by the process that they're not really good for much. And here's the final thing that's really sad is that then you have a trial record like we have here that's wrong, and it's led people to remember things wrong, to remember things that didn't happen and not remember things that did. And that's why when we come to the Serial podcast originally, we have this guy, Adnan, that doesn't remember anything. He doesn't remember anything because of the process and the investigation, but because by being part of the trial and being fed all this wrong information, he's remembering things that didn't happen and not remembering things that did. And that's the thing that frustrates. Frustrated me. Well, I won't say it happened when I saw the podcast because I could be wrong, but it has since then. That we don't have any idea what happened because people who once might have known what happened don't. They don't remember anymore because it's all been driven out of their minds. And I really think that is what happens. And I have some personal anecdotes from life about memory like that, but this is already going on far too long. The other thing I want to say, and the only place I'd have any quibble with what Bob said, was you may have remembered in the podcast, he talked about why did the investigators bring in this thing about Adnan and Hay getting together intimately at a hotel at some point, and said, well, maybe there. And Bob thought, well, there must have been some evidence of that happening, and I don't know. I haven't been deep on Reddit. Maybe there is, but I had a different response. When I'm taking a deposition, there are a lot of tactics and techniques you take to try to get information from people. I wouldn't call them tricks, but you have to present questions in a way that can get beyond a person's defenses, training. Because if I get to, let me give you an example. Firm I work at, we represent mostly Fortune 500 companies in a product liability, mass torts, and class actions. And again, there's two sides to every story, so I'm not trying to push any kind of agenda here. But what often happens in product liability cases is for different reasons, because of immunity or bankruptcies, or because the government maybe was the worst culprit. That's certainly, in my opinion, is the case with asbestos in the military, and the government in many ways is immune from lawsuits. When the plaintiff, the asbestos plaintiff, who often is very sick, or it's a family member of someone who died from mesothelioma, when they come to time in a deposition to identify a product, they tend to remember the products that are associated with your client and not remember the products that are associated with their work with the military and bankrupt entities. And why is that? It's not because, I'm convinced of this in most cases, I mean, I have to say that any group of people, plaintiffs who are dying from terrible diseases like mesothelioma or whatever, are the most wonderful people in the world. So I've been in tears during those depositions, because just in sadness, but also in admiration for a lot of these people. Anyway, a lot of it, I think, is because when they bring this lawsuit, the plaintiff's lawyer obviously knows what's at issue in the case. And what's at issue when you're a plaintiff is not that there was this tremendous exposure to asbestos when I was in the military in World War II, because you're not going to get anything from the government. It's whatever thing happened when I was sanding a house, doing home work on a home project in the 1960s. And so when that plaintiff, who maybe hasn't thought about any of this stuff in 50 years, they had not thought about what joint compound they were using when they were building their house from scratch and using a kit in the 1960s. So they remember what is useful to remember and don't what isn't, because that's what they're presented. And so the point is when I'm taking a deposition, I'm going to try to take into them out other sources of information, maybe newspapers, maybe other things that might suggest to them that there's more to the picture, so we can paint a full image. Okay, I was going somewhere here. So that's what I do in product cases. Oh, yes! Sorry. This hotel thing. So sometimes when you're doing that, you don't want to necessarily have a narrative line of questioning. You want to move around a little bit. And the reason is, and I don't think it's dishonest, you want to reverse engineer some of that programming they've had from their lawyer to get at what you think is a more realistic picture of what happened. And so you do that by breaking up their story so it doesn't go along with the narrative that they have in their mind about what happened. That they've been. Oh yes, okay. So someone pointed out that what Bob was saying is the questions about the hotel might point to there being evidence of a hotel room, not that they did that. That's not my point. I'm sorry, I'm being very long-winded. My point is that the hotel question might have been not a ruse, but a way to distract Debbie so she wouldn't backtrack on what she said. Because a kind of witness like Debbie is going to be maybe long-winded, and is going to be in a kind of stream of consciousness when they're talking. And so if you allow them to just think and sit on a question, they're going to keep adding stuff. And they might add stuff that's not helpful. So I think that's what the police did, my thought, was they had the hotel thing after they got a real zinger to get Debbie not thinking about, well, what did that mean when they got that zinger? Because again, she doesn't know necessarily what's important. And so I think that's what was going on with the hotel. I'm thinking this investigator said, okay, we got her on, hey, maybe, and I forget all the details, maybe Adnan got the ride in the car. Maybe they were out getting together in a park. And what about a hotel? And she's like, hotel. And she's not thinking about the park. So I think that's probably what happened, but I could be wrong. Okay, that's all I've got. I'd be happy if anyone's got any questions or comments or anything like that. I talk longer than I intend to, which is pretty much always the case. You can ask my wife. But if anyone's got any thoughts about anything, I'd be happy to address it now. Thanks, Brendan. Well, thank you. And one other thing that I'll just say, and I'm gonna get out from this, is some of you know I am with two other lawyers in the Twin Cities area launching. Doesn't that sound so, I don't know, grandiose? Starting a podcast called the Serial Lawyer Podcast, and it's about. It's going to follow Serial Season 2, which should be starting within the next few weeks. And so we're going to just talk from some of our perspective of lawyers, but also as storytellers and touch on a lot of other things, just like the first season of Serial did. And we're planning on bringing in some people, interviews who, let's say if it's an issue about memory or forensic psychology, we would bring in someone like that. And we would have them, and it would be part of what we're talking about. So that was not a very good explanation. But that's... Yeah, someone said, I think Serial will stop using the word serial in your podcast name. Maybe. They might. They didn't do that last time, but they could this time. So we'll see. The following shows, like Slate and Onion did last year, had they had serial in their title. But if so, then we'll just work with it. I mean, hey, it's a champagne problem. If there's enough people are there listening, that it would come to their attention. I think someone said why Bob's changing it. I think there was, maybe, I'll ask Bob, I think part of the problem was his logo had a bunch of serial stuff on it. So someone said, I want them to study legal topics anymore. That's great, and I should say that I really believe that if the legal system's going to improve, if we're going to do things better, we're going to need to have involvement from non-lawyers, because a lot of lawyers, we've been trained in ways that aren't helpful. But someone said about the appeal process, so I just want to say kind of a background, not a criminal defense lawyer, but where things stand now is an appeal. When you appeal something, the record and the decision that's being made by the appellate court is often pretty limited. So whereas at trial, right, any day at trial, I can have a witness, I can do lots of stuff. An appeal, with few exceptions, you're limited to the record that came out at trial. So Adnan Syed is limited to the record at trial, and in most cases. And so what's going on now is we have an attempt to supplement the record because of misconduct, generally, either ineffective assessments of process or maybe a Brady violation. And so as supplementing the record and maybe getting into trial, that's where the Asia affidavit comes in, that's where the cell phone records comes in. And someone said it's convoluted. Well, that's a good point. The problem is that you want to have a fine result, and if at every level of the process you're retrying the case, it can be really difficult. And the idea is that the reason why the appellate court doesn't create a new record, and in most cases there's something called the standard of review. In most cases they don't do a de novo review of the facts, meaning they don't put new eyes on the facts and look at them anew. They apply a standard that the trier of fact, whether it's a judge or a jury, in some cases even the trier of fact can be a judge. I don't think in criminal cases, but in any event, they entitle them to more weight because they were there, they saw the witness, they were there for the whole time. They don't think the appellate court should make that decision. So that's it. It's too bad, and that shows why it's so important that things are done the right way, the right time by the trial lawyer. And if you don't, it's unlikely that you're going to be able to fix it on appeal. So that's all I've got. Thanks for being here. My YouTube channel, which I think if you just put in Brendan Kenny, maybe Brendan M. Kenny, you could find it. I haven't really done much work on my YouTube channel, but I do have a playlist, and that has all the stuff I've recorded about the Adnan Syed case, including one I just added that I had recorded myself that hadn't been posted anywhere, that I did back in November 2014. So it's at the very beginning. You might just check it out just for fun. I think it's only 14 minutes. I don't know why it would be fun, but you might see whether I'm totally full of it, and I was didn't know anything about the case back then. So anyway, enough out of me. I'm gonna go. Thanks so much. You can find me on Twitter at Kenny @KENNY Brendan BRENDAN. And if you're interested at all in the new podcast, we have an email. Serial Lawyer SERIAL LAWYER, so 2 L's, SERIAL LAWYER @gmail.com. Any involvement, if you want to help in any way, even if it's setting up a fan thing on social media. Obviously, you want to hear something first to see if it's any good, but just contact me that way as well. All right, that's all. Have a good result. And at every level of the process, you're retrying the case, it can be really difficult. And the idea is that the reason why the appellate court, doesn't create a new record, and in most cases, there's something called the standard of review. In most cases, they don't do a de novo review of the facts, meaning they don't put new eyes on the facts and look at them anew. Result. And at every level of the process, you're retrying the case, it can be really difficult. And the idea is that the reason why the appellate court, doesn't create a new record, and in most cases there's something called the standard of review. In most cases, they don't do a de novo review of the facts, meaning they don't put new eyes on the facts and look at them anew. They apply a standard that the trier of fact, whether it's a judge or jury, in some cases even the trier of fact can be a judge. I don't think in criminal cases, but in any